Hi, this is Victoria Nalule, and here with me is Professor Cameron and Brandon Malone. Today we're going to discuss on international arbitration, and we'll have two series of videos. The first one is dedicated to students and those who don't have a lot of knowledge with regard to international arbitration. And in here we'll talk about the state of arbitration, what to consider when drafting an arbitration clause, and also we'll talk about the typical steps in an arbitration. And then the second series is dedicated to practitioners and experts. And in here we'll have three videos. The first one is we'll focus on what to consider when choosing an arbitral tribunal. The second one will discuss more on the developments in energy disputes. And the last one will talk about the limitations and challenges in international arbitration. But before we start, I'd like Professor Cameron to introduce himself, and then Brandon will also introduce himself.
Hello, I'm Peter Cameron, a professor and director of the Centre for Energy, Petroleum, Mineral Law and Policy at Dundee. I've done quite a lot of expert work in arbitral proceedings and also sat as an arbitrator. So it's a great pleasure for me to be sitting here and with Victoria and addressing this important topic.
Thank you, Professor Cameron. Brandon, would you like to introduce yourself?
Yes, thank you, Victoria. I'm Brandon Malone. I'm a lawyer and an arbitrator based in Edinburgh and also in London. I have my own practice, Brandon Malone and Company, and I work with Quadrant Chambers. I am the chairman of the Scottish Arbitration Centre, and also together with Peter, we are co-directors of the International Centre for Energy Arbitration.
Thank you very much for the introduction. So the first video, we want to talk about international arbitration as an introduction. Why international arbitration in this era?
Well, there's been quite a lot of research in this. We've got quite a lot of data about that, people's preferences. One of the most important reasons, if not the most important reason, is international enforceability. And that's a major advantage of arbitration over litigation. With the arbitration regime, we have the New York Convention, which is an international treaty, which means that where there is an arbitral award in one state, then it can be enforced in any other convention state. Now you contrast that with litigation, and there isn't this comprehensive system of reciprocal enforcement. So the award of one court might not be enforced in the courts of another country, and that's obviously a difficult problem if the assets are based there. Now there are some moves to try and address that. There's the Hague Convention and that kind of thing, but it's not widely adopted. Okay. So that's the number one reason. Another reason is that often parties are keen to avoid the courts of certain countries. Okay. Someone might want to invest in a state, but they're unhappy with the courts in that state because they're not reliable. There might be corruption in those courts. So the international arbitration regime allows them to invest in that country, knowing that there is a supranational system that will allow them to enforce the contract, enforce their rights, enforce their investment, and protect their investment. Whether you consider that a good thing or not, I suppose, depends on your point of view, because it does mean that countries that may not have respect for the rule of law and an effective court system can attract investment. Well, that's obviously good for the investors. It's good for the governments who are seeking to attract that investment. There's an argument it's also good for the rule of law, but I suppose the reverse argument to that as well, if these countries couldn't get investment because there wasn't an effective regime, then maybe they'd have to bring along their courts and advance the rule of law. But I think the general consensus is that the international arbitration regime is bringing the rule of law to a lot of states where it doesn't currently hold sway. A reason related to that is neutrality. You might have a situation where the states are very comfortable with the courts in either state, but or the contracting parties rather, but they don't want to give the other side a home turf advantage. So they like the idea of saying, well, you don't have to come to my court, I don't have to come to yours, we'll go to a neutral venue. And that could be a neutral court, but that's more complicated. So the system of arbitration is already there to allow for a neutral venue where neither side has an advantage. Another reason is flexibility. Court procedure can be quite rigid. It's set out in detailed rules. It's a very formal environment. It's not very business-like. You know, people are in wigs and gowns and speaking Latin and all this kind of thing that you associate. And it's perhaps not exactly like it is on television, but quite often it can be that way. Whereas arbitration has scope for being much more commercial. Business people sitting around a table, and it's I wouldn't say it's necessarily a friendlier environment, but it's certainly one people are more used to. A big reason that parties give for choosing arbitration is party autonomy in the process. So you're able to select arbitrators. The traditional or the prevalent way of doing it in big international arbitrations is that each side will select an arbitrator and they will between them appoint a chair. Now the arbitrators of course are meant to be entirely neutral and to decide in a neutral way, but it's that advantage of being able to appoint someone who will understand your jurisdiction, where you're coming from, your industry, for example. That's an advantage people like. Another important feature of arbitration is confidentiality, and that is a reason particularly in-house counsel, perhaps even more so than agents, really value. It's a private process. In most states it's a confidential process, and if you seek your arbitration in Scotland, for example, we have a very strict confidentiality regime, an opt-out confidentiality regime, and that is what is favoured by in-house counsel, particularly in energy companies. And finally, I think a big reason is finality. If you go to court, you can get appeal after appeal, and that necessarily lengthens the process and adds to expense. With international arbitration, you can of course challenge if there is some sort of technical breach of jurisdiction or if there's bias or corruption, the usual reasons you would expect. But by and large, their decision on the merits and on the law is final. There's not usually going to be an appeal stage, and so that shortens the process and it gives certainty.
All right. Thank you very much, Brandon. Professor Cameron, do you want to add something?
Well, I agree with all the points that Brandon Malone is making there. Let me just add very few points. One is, as he said, investors like to have the comfort of knowing that international arbitration is available with respect to their investments, particularly if they cover large, long-term, complex projects in which a dispute may indeed occur. So, I mean, one hopes that the dispute isn't going to happen, but if it does happen, you should have planned well in advance for a procedure. So, I mean, that's probably the first thing, the comfort of having something. Secondly, I think one should be aware that international arbitration can be provided through the contract. It can also be provided through an international treaty. That's where a government has made a treaty with a bilateral investment treaty with another country, in which it says that investors from that country can, if they so wish, make claims against it at a future date in the event of certain circumstances happening. So you could find that you have an international arbitration occurring on the basis of one of these general treaties, which could be a bilateral treaty. It could be, I don't know, it could be Nigeria and Morocco, for example, within Africa, or it could be a multilateral treaty like the Energy Charter Treaty. If you're a party to that, then various kinds of arbitration procedures are possible. And I think probably that the only other point I would add to what Brandon has already said is that you always want to accompany your arbitration procedures with not just the comfort to an investor, but the comfort to both parties that if they can settle their dispute without either going to arbitration, or even when the arbitration is continuing, they can bring it to a stop by reaching an agreement that keeps them both happy. And one should always be trying to encourage people to do that. That disputes are most unfortunate, they're not good news, and one should be trying to bring them to an end at the earliest possible opportunity, if one can. I think that's all I would really add to the very good points that Brandon's made.
Okay, thank you very much, Professor Cameron.